Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today again we'll continue with the topic, the meeting of the board and its power. Right? In the previous lecture we have already discussed the provisions of section 174 and section 173. That is, the quorum of the board meeting and the resolution by circulation respectively. So today we'll be covering the questions that have been asked in your past year examinations and also some other questions that could be framed on this topic. Right? Obviously that will not be the exhaustive list because you may have some other questions too. It would be inclusive, but we'll still try to cover the maximum number of questions that we can think of and that have come in your examinations. So before going to the question part, we would first like to briefly cover up the section 174 and 175 as a revision, right? We'll just go rapidly through it. We'll take 2 minutes behind it and then we'll begin with the questions. So revision of section 174 and 175. First we'll pick up section 174, that is the quorum of the board meeting. So as we have already covered, right, when we were discussing this section, that the quorum would be higher of either 1/3 of the total strength, right, and that would be rounded up, or 2 directors, whichever is higher, right? So 1/3 would be rounded up always, remember that point, right? And even if a director is present via the mode of video conferencing, we would consider him to be present for the purpose of quorum also, right? And we have also seen, while we were discussing the concept of voting in the board meeting, that the interested directors are not allowed to vote in the board meeting, right? So if the total number of interested directors, right, they go beyond 2/3 of the total number of directors, right, then the quorum would be all the directors which are greater than 2, because obviously we don't have 1/3 directors left. Right, because when interested directors cross 2/3, that means non-interested are less than 1/3. So we cannot have 1/3 as quorum. Right? Then we cannot say that we haven't met the requirement of quorum if there are like 4 directors remaining in the meeting, but we needed 5 for the quorum as per the 1/3 rule. If there are 15 directors, so that would not be the case. If there is any kind of a situation where we cannot have 1/3 of the strength of directors as not interested in the contract as eligible for voting, then all the other directors, that is between 2 and below that limit, would be considered for the quorum, right? And if the quorum is not fulfilled, then the meeting would be adjourned, and that would be adjourned to the same place, same time, same day in the next week. And if that next day is a holiday, is a national holiday, then the succeeding day, which is not a national holiday, right? And this would be done unless the article otherwise provides. That means if the article specifies some other day, then we would consider that day for the holding of the adjourned general meeting. And we have also seen that if there is a situation whereby the total number of directors, they go below the requirement of quorum, right? If the total number of directors fall below the requirement of quorum, that means the board will never be able to fill the quorum up, right? That means they will never be able to abide by section 174. That means will they never hold a board meeting? The answer is no, right? So you have a way out. So if there is a situation where the total number of directors, they fall below the quorum, then the board would transact only 2 matters by holding the board meeting. One is the meeting, that they'll conduct the meeting to increase the total number of directors, right, so that they can have the required amount of directors in the board to manage the company as well as to meet the requirement of quorum, right? And second is they will meet to summon the general meeting, right? They'll call a general meeting to discuss those provisions, those resolutions that are not being able to be conducted in the board meeting, because the resolutions cannot be carried forward in the board meeting, as the board meeting cannot be held, right? Because there is no quorum at all. The total number of directors has fallen below quorum, right? So these were the provisions in brief that we have seen in section 174. Next we'll move on to section 175, resolution by circulation. Now what is resolution by circulation? If you remember, right, resolution by circulation is actually a resolution that is passed outside the board meeting, where the members do not actually meet, What happens is that a draft is prepared and all the other documents are attached to it, and then it is circulated to all the directors, and then they sign and return it back. And then if we have a majority over there, we call it the resolution by circulation. So if we go by the steps, the resolution along with necessary papers are circulated in draft to all the directors. And where is it sent? It is sent to the registered address, right? And in this case, the registered address should be in India. If it is outside India, we will not send him the resolution by circulation. We will not send him the draft, right? And once they receive the resolution at the registered office, then they will approve it and send it back, right? And the resolution would be approved only if it is approved by the majority directors who are entitled to vote. That means who are not interested. Okay? But in between these two processes, in between sending the draft and receiving the approval, right, there is one more step that could be taken by not less than 1/3 of the total number of directors, right? So 1/3 or more directors could actually want the resolution to be passed in the board meeting. They are not satisfied by the circulation process. They want no, this resolution would be passed in the board meeting. Let us all come, meet, discuss and decide as to the progress of the act, whatever they are planning to do, right? So if that is the situation, that is the condition, then the chairman shall put the resolution at meeting, would call a board meeting, and then the resolution would be put at the meeting, and then over there it would be decided. And why is the limit of not less than 1/3 specified over here? Because 1/3 can by themselves form a quorum. If other directors do not agree, still they themselves can go and hold a board meeting, a valid board meeting, because they will be able to suffice by the requirement of the quorum. And once the quorum is met, they themselves will sit down and decide whether or not to pass the resolution. If other directors are not coming, they don't have a problem with that, right? So finally, whatever resolution will be passed in the resolution by circulation method, that would be noted in the minutes, right? But in which minute? The minute of the subsequent board meeting, right? Okay, so these were the provisions of the two sections, provisions of the act, section 174 and 175. Now we move on to the questions. So first we'll pick up the questions of section 174, right? So if I show you the list, we have so many questions appearing in your examinations from 1994, 95, 99, 2000, 2005, 8, 9, right? So very recently you did not have a question. So all the questions that you had were before 2009, right? And if we see the questions for section 175, then you had the question in 1995, 97, 98, 2000, 2002, 2007 and again 2009, right? So these two sections, you have had a lot of questions in your examination, but those questions appeared long before, that is before 2009, right? So let us discuss what are the type of questions that have been asked, so that even if this section is asked in future, we are prepared with the types of questions that could be asked, right? So quorum of a board meeting has actually been an important topic over the years, right? Because even if you don't have a direct question from this section, you may refer to this section in your answers, right? Whenever you have a topic, whenever you have been asked a question from this chapter, when you talk about the board meeting, you can always give a reference to this section 174 about quorum, because if there is no quorum, the board meeting cannot be held. Obviously, unnecessarily you won't involve it into any question, because that won't fetch you marks and that will make your answer cumbersome and that will take a lot of time. So I'm not talking about unnecessary insertion, right? But there can be a requirement of this section overall, right? You could have a reference to this section. So in December 1994 and then in June 1999, you were asked a very simple question as to what is the required quorum for holding a board meeting. So you'll have to say either we'll have 1/3 of the total strength or 2 directors, whichever is higher. That is all. That is all that you have to answer over there, right? And next, in 1995, you had been given a case, right, whereby the company had 11 directors, out of which only 3 were present, right? And none of them were interested. So they wanted to put forward a question whether it is a valid meeting. So how do you basically answer this question? First of all, you will have to write down the provisions. So you will have to write down the entire provision of 174, that you need to have 1/3 or 2 and so, whatever we have just discussed, right? I will not be repeating it and taking your time again and again. Then after that, you will have to go to the case, right? So in the given case, we have seen that there are total strength of 11 directors and 3 are present. So if there are 11 directors, so as per the requirement, we need to have 1/3 director for the quorum, right? So 1/3 of 11 is 3.67, which would be rounded up. That means you need a minimum of 4 directors, 4 disinterested directors. And what you have in the question is 3 disinterested directors. So will the meeting be a valid meeting? The answer is no, because you don't have the quorum, right? And since all the directors are not interested, so you don't even get the benefit of interested directors. We have seen, because in the situation where more than 2/3 of the total number of directors are interested, right, then 2 or anything above that who are not interested would be considered to be quorum. So if that was the case, if more than 2/3 were interested, then even 3 would be considered to be a valid quorum, but that benefit will not be available to them. So you will also have to write down this point in the answer. Generally what you do is, okay, 11 divided by 3, it is 3.67, so rounded up to 4, but we have only 3, so it is not a valid meeting. Over. The answer ends over there. But no, you will have to check the other provision too, right? So please keep these little things in mind, because that is what is going to fetch marks for you in the examination, right? Otherwise you will think, okay, I've given all the right answers, but where are my marks? The institute does not want an incomplete right answer. An answer for the institute is right when you have analyzed it from all various provisions, right? From all angles. When you have knocked it and you have find it right, that is when you give the conclusion and you specify that, yeah, these are the areas where I have knocked. You have marks based on those areas, right? Then in 1998, you were asked a simple question as per the procedure that is to be followed for an adjourned general meeting, right? So that is very simple. You will write that, yeah, that will be conducted in the next week, same day, same place, same time, right? And if it is a public holiday, in the succeeding day, which is not a public holiday. And if there is something else provided in article, then we would follow the article. That is it. That is all that you need to write in this answer, right? Because these type of questions are actually very simple and very easy. Because anyways, whenever you are given a case study, you anyways have to write the provisions of the section, right? But what is the benefit of these kind of questions? That only writing the provision would work. Write down the provision that you anyways had to write, right? And your answer is over. You don't have to give a conclusion or a interpretation, right? So those things are not required. So these kind of questions makes your task very easy, but in your recent examinations, you don't get such questions anymore, right? All the questions that you get are basically based on case studies, where you have to write down the provision, analyze the question, and then give your judgment on the same, right? So in 2001, right, you were asked that there's a company, right, whose third board meeting was due on 30th September, right? They called a meeting, but due to the lack of quorum, due to want of quorum, the meeting was adjourned, right? And then it was held in the next week, right? But actually it was not adjourned. The question that just said that the meeting could not be held for want of quorum, right? And then you have to advise what is to be done. So the first thing is, over here what you say is that this question, or since it was asked in 2001, it also pertains to the previous act, right? It actually gives a reference to the Act 1956, where you had to hold a board meeting in every quarter. But as per 2013, there is no such requirement, right? So in any ways, the answer to this question would change now. But what I actually want you to understand, why am I discussing this question, is that you could get a similar case at the end of the year, right? We have discussed it while we are discussing section 173, right? So you could get such kind of question. But over here, the only point why is it included in this section is that the meeting could not be held due to want of quorum, So what does the act say? The act says that the meeting should be adjourned to the next week, same day, same place, same time, and all the provisions that we have already discussed. Right, so that is the only change. And why I discuss this question is basically so that you understand the difference between the provisions of the Companies Act 1956 and the Companies Act 2013. Right, over here we don't have a provision of holding one board meeting in every quarter. Make it very clear with you. Right, in 2005 again you had the similar question, but there was another extension, right, that asked whether the director is bound to attend all the board meeting. And that question also included a part where a board meeting was duly called, but it could not be held, right, due to the reason of quorum. It could not be held due to lack of quorum, right? So give your advice on that, whether it is a contravention of the act or whether it would be valid. Right, over here also you mix section 173, right? So first thing is that yes, the directors are required to attend the meeting, although not all board meetings. He should actually endeavor to attend the maximum number of board meetings that he could, but he is not duty bound to attend all the board meetings. But there could be a situation where he would be asked to vacate the office too, right? Now when would that arise actually? That would arise if he is not attending the meeting and as a result the company bears a loss, right? So over there it would be considered to be a negligence of the director because the company is bearing loss due to his continuous absence. So that could be a situation where he would be asked to vacate the office, right? And that doesn't matter whether he was absent with or without permission, right? So that was one. And the second part of the question was whether the provision of 173 would be considered to be valid, would be considered to have been complied with. So as per the previous act 1956, if the meeting was called and could not be held due to want of quorum, the provision was valid, right? This act was valid, it was justified. Okay, you had called the meeting, you had an intention to hold the meeting, but due to the lack of quorum you could not hold the meeting, so we won't penalize you. You did not contravene the provisions of the section, right? But for Companies Act 2013, right, the provision is a little different. If you had called a meeting and could not be held due to want of quorum, it would be adjourned, and if the adjourned meeting is held, it is valid. So even if the adjourned meeting is held in the subsequent calendar year, it would be valid. We had already discussed it while we were discussing questions on section 173, right? But now there is a problem that what if the adjourned general meeting is also not conducted due to want of quorum? Then that means there is no meeting conducted at all. In that case also section 156, the provisions of Companies Act 1956 says that it is valid. It says that it is not a contravention of the section 288, right, if we refer to the previous act. But as per section 173 of 2013, that would be a contravention of the act, right, because it says you will have to hold 4 board meetings. So you have to hold 4 board meetings. If you cannot hold a board meeting, and even if the reason is the lack of quorum, that would be considered to be a contravention of the act. So this is another difference that we found out between the Companies Act 1956 and the Companies Act 2013, right? And my dear friends, if you actually want to know the differences, if you want to understand the difference between the provisions of Companies Act 1956 and the provisions of Companies Act 2013, please refer your study material provided by the institute. Right over there at the end of each section you have been given the comparison. That would be very helpful for you. That would be more helpful than the books of any authors, right? In again 2009 you were asked a similar kind of a question, so we will not repeat that. But in 2008 you had a different question altogether. So in that question what basically happened was that the board meeting was duly started, right, with the required quorum and everything. So there were 10 directors and out of which 7 directors were present in the meeting. So the quorum was fulfilled and the meeting was duly convened, right? But after the noon, after passing few resolutions, 4 of the directors, they left the board meeting. They left the room, right? And then there were 3-4 more resolutions that were passed. So the institute wants you to answer on the validity of those resolutions that were passed after the 4 directors had left. right? So there is just one point to remember, that the quorum is not just required in the beginning of a meeting. It has to continue throughout the meeting, and the quorum has to be maintained with each and every resolution, right? So no resolution would be passed if there is a lack of quorum, right? That is very simple, right? So you know how to answer. You will have to write the provisions and then the analysis and your conclusion, right? So, and referring to the other questions, I would like to discuss two cases with you, right? For example, if the company had conducted 3 board meetings through the year, that was validly conducted, right? There was no issue with that. But the 4th board meeting, suppose that is, as we have already discussed in earlier one question also, that it was supposed to be held on 28th December, right? But that could not be held due to want of quorum, and then it was adjourned, right? So when it was adjourned, the meeting of 28th December was adjourned to the next week. So the next week would definitely fall in the next calendar year, right? So now there are two cases. Number one, that the adjourned general meeting also could not be held due to lack of quorum, and the second situation is that the adjourned general meeting was validly held as the quorum was present and everything was okay, and the adjourned general meeting was conducted and the resolutions were passed, right? So now we have to actually advise on the validity, right? We have to see whether any provision has been contravened, right? So if I try to bring it back to your mind, then in the previous lecture, we have not the immediate previous, but while we were discussing the questions on section 173, we have discussed a similar case, right? But that was regarding only the limits of the meeting, and over here we are discussing it regarding the quorum requirement, right? So in the first case, the quorum was not present in the case of the original meeting, but it was present in the subsequent meeting, in the adjourned meeting. So since the adjourned meeting is supposed to be a continuation of the original meeting, hence the provisions of the section 173 is not contravened, right? So that meeting would be deemed to have been held in the calendar year in which the original meeting was supposed to be held, right? And in the second situation, the provisions of 173, there is a contravention of provisions of section 173, right? Because no meeting was held at all. Even the adjourned general meeting could not be held, right? So that is all that we need to discuss with section 174. We were supposed to discuss the questions of section 175 too, but now we'll take it up in the next lecture, right? So until then, this is Abhinay Gupta signing off.